My clients allege that their brother, Bruce White, had their mother, Eva Lou White, execute a new will the day after their father had died, which disinherited all of the siblings except for Bruce. And they filed those claims against him, and they reached summary judgment, where summary judgment was entered on all of them before the court in favor of Bruce. So the question before the court today then is on de novo review. In the taking the evidence in the light most favorable to the appellants, was there a question of material fact here that should have prevented the entry of summary judgment? The trial court held, in its words, there was not a, quote, scintilla of evidence here to support any of the claims. And I would submit to the court that not only was that not true, the opposite was in fact true, that the evidence was so overwhelming that the presumption of fraud arose and the presumption of undue influence arose. And the trial court should have held that Bruce, not the appellants, had the burden of proof at summary judgment. I know the court has already read the briefs, and I know the court doesn't like going through the facts in these oral arguments, but given the posture that we're here, I think a review of some of the facts is important. As I just mentioned, this new will was procured the day
I
after.
apologize. I apologize for interrupting you, but there are a lot of questions, as I think you probably alluded to. So I would like to jump into a couple of them at this time, and certainly feel free to bring out the facts that you think are relevant in your answers to the questions. In looking at what was presented to the court for summary judgment, was there any documentation from the doctors regarding any formal diagnosis of dementia that was provided in connection with it for Eva Lou, in connection with this motion for summary judgment?
So not all of the records of Eva Lou medically made it into the record for summary judgment. Some of them did, and some of them didn't, and I couldn't tell you why. The ones that did make it in, and actually some of them are in the record, but they came in later on at trial. So they're in the appellate court record, but not at the time of summary judgment. There
And
were,
the
however,
trial would have been the trial for on the issue of testamentary capacity.
correct. So
Correct.
at that trial, the doctors did testify to the diagnoses of dementia. At summary judgment, for some reason, not all of those records made it into the record. But
And
some of
then
them,
if I can just add, then including the cause of death being senile dementia, that wasn't submitted either with the motion for summary judgment.
I don't believe it was. I believe the
Okay.
records at the time were exclusively from Dr. Chamberlain. And the most operative one, I believe, is from 2017, in which Dr. Chamberlain discussed, I don't know that he used the word dementia specifically. He used the words paranoia, and he talked about how she thought people were stealing from her, how he thought she needed treatment for the paranoia, but didn't want it. And most importantly, for purposes of summary judgment, that in his opinion, she needed assistance with every activity of daily living. And that was in 2017. So then we fast forward to when this all occurred, which was in the beginning of 2019. So at summary judgment, Bruce claimed that he never assisted Eva Lou with any activity of daily living at all, financial, eating, cooking, cleaning, nothing. In contrast, at summary judgment, Dr. Chamberlain's evidence was she needed assistance with every single one of those things. And to your Honor's point, there was more information that came out later after summary judgment that certainly is stronger evidence to show that she did in fact have dementia. But also at
So
summary,
at the time, so thank you for your answer. At the time, she executed her new will, which is the time we need to focus on. What evidence was submitted to the court, again, in conjunction with this motion for summary judgment, to show or evidence that Bruce acted in some way to overcome Eva's free will, or that he procured the will for her, other than the fact that he gave her the contact information for Mr. Collins, his attorney?
so you have to look at the totality of the circumstances when you're determining if undue influence was exercised or not. And as I stated, there are a lot of facts here that lead up to undue influence. It doesn't have to be direct evidence. Undue influence can be wholly circumstantial. It can be inferred from the evidence, and the evidence had to be taken in the light for my clients weighed in their favor. And when you look at it that way, what we have is a situation where Bruce admitted that Eva Lou was in a grief-stricken state. She was not sleeping. She was not eating. She was crying all night. Her husband had died the night before. And yet somehow she got up the courage to say, I want to get a new will. That is what Bruce says. Well, the lawyer that they got was Bruce's lawyer that he had used many times before. And if you look at the evidence of what the lawyer testified to, you will see that this was a highly out of the ordinary scenario. The lawyer said he almost never does wills over the phone. I think he testified to maybe a couple dozen in his career against 500 or so that he's done in person. So he doesn't like to do these over the phone. But when you look at his notes, you see information in his notes that, again, matches with all the evidence of the dementia, that she was continuing to make false statements about people stealing from her. She made a false statement that she that she gave away a farm to her son, which didn't happen. She stated the wrong day that her husband had died, even though it was just the day before. She got the name wrong of one of her children, and none of her other children
But
knew this was
she
going on.
knew her assets. I mean, what's required at the time? She has to be oriented to know her assets, know how she wants to dispose of them, correct? None of
No,
that was, pardon?
no,
Go ahead.
because what you are talking about is testamentary capacity. And
Okay,
and what we are talking about here is undue influence. Undue influence and testamentary capacity are two entirely different things. And I know
exactly.
Bruce argued in his response that, well, we already had a trial on testamentary capacity, and that's true, we did, and I'm not appealing it here. And the reason I'm not appealing it here is because the Supreme Court has held in re Estate of Hoover that it just simply doesn't matter. That testamentary capacity and undue influence, one has nothing to do with the other, because she could have dementia and still have testamentary capacity to make a will. But the worse that her mental state is, the less evidence is necessary to create a reasonable inference of undue influence. And under the circumstances here, I think we have more than met the presumption of undue influence that looking at all these facts.
Well,
Again,
let's look at the couple cases you cited in your brief. The Burren case, I have to look at my notes here. Burren and, one second, the other two cases that you cited as well with respect to procuring a will and the facts there. Are not those cases distinguishable? Because in this case, Bruce didn't take her to the office of the lawyer. Apparently, she called the lawyer herself, spoke with the lawyer herself. He, according to the witnesses, was not present for the execution of the will. So the cases that you cite with respect to the undue influence really are not the same facts that we have in front of us in this case, are they?
none of the cases on undue influence are ever going to be the same facts because they're always under the circumstances at the time. So the cases that I've cited are not for trying to say that they're on all fours with another case, because they're not, and you're never going to find one that is. But it's about the general prospects of procurement and what happened. To your point about the witnesses that he procured, I would reject that what they said was accurate, because as I pointed out, and as the trial court even pointed out, one of the things that the trial court actually did raise was that the affidavits that Bruce put forth from the bank witnesses that witnessed the will were contrary to how they testified at the prove up 2 or 3 years earlier. If you look in my reply brief, I've isolated the sections of the prove up testimony against the affidavits, because at the prove up, they said Bruce was there. They said that Bruce was the one who came into the bank and told them to come to the house. And one of them even said Bruce was there at the time that it was signed and told them to sign it. She made a statement that said, well, Eva Lou was in the conversation too, which sort of implies that Bruce was the one doing all of the talking there. So when you look at those two competing, the affidavit versus what was testified to originally, and weighing that in the light most favorable to my clients, the evidence at summary judgment was Bruce was there. Bruce was there when it was signed. Bruce told these witnesses to come there, and Bruce told them to sign it. And under those circumstances, there are some of those cases that I cited that is close to those facts, where they hold that the person who, quote, brings the will to the table, that alone establishes a presumption of undue influence. And that's what
You're
occurred
saying,
here.
how did he bring the will to the table? What facts? Are you relying solely on the differing affidavits, or is there something else that was?
No, there's more. If you look at the testimony from the attorney, he talks about having conversations with Bruce that neither he or Bruce can remember what they are, but that he said it was very strange for him to be having conversations with the beneficiary of the will. One of the things that did come out from these conversations, though, was that the attorney was told when to send the documents to the house. He was specifically instructed by Bruce not to send them until the day of the funeral. And I think the reasonable inference there is that Bruce didn't want anyone seeing them before then. The inference being that his siblings are going to be present at the time when the funeral occurs. And if they show up to the house and get the mail, because this is a farmhouse with a very long driveway that Eva Lou couldn't get her own mail, if they got this mail and saw it was from the attorney and gave it to her, they were likely to find out what was happening. There are other cases that say when a beneficiary procures a
Had they
will.
been, counsel, if I may, had they been frequenting the house though? My understanding is they had not been having communications with her.
Two of them had not been frequenting the house, but one of them had. Christina had been coming to the house quite often. Vicky had not been coming around, nor had Mike, because they had made this decision with their father that it was making his life difficult because she would accuse them all of stealing. She had tried to hit Mike at one point with a chair, and they had basically decided we're not going to come around. But Christina had been coming around for quite some time before that. I believe she testified she would be around 3 to 5 days a week.
And was
But
Attorney Collins ever asked who was present for the actual signing of the will? Because I know there is some conflicting information as to whether, it suggested Bruce was there, but being there does not necessarily mean in the room while the document's being executed.
correct. And that is another interesting error here with what happened with the signing of the will. To answer your question, Attorney Collins does not know because he was not present when the will was signed. Attorney Collins testified that he normally wants his clients to show up to his office and have all the documents executed in his office with his witnesses. For whatever reason, that did not happen here, and Attorney Collins did not really explain why.
Didn't you suggest a reason? You said that she couldn't even go down the driveway to get her own mail. And
So
the assumption is that, knowing the towns here, that we're talking 20, 30 minutes away for the lawyer's office. Isn't it that sort of a suggestion as to why she didn't go into his office?
it was a suggestion. There was a vague suggestion in the notes that there was some mobility issue that prevented her from going to his office, but Mr. Collins didn't know why. And when you look at the facts surrounding it, she actually went on multiple trips of the same distance that same week that she signed the will. She was incapable of driving herself, so she was entirely reliant on Bruce to take her to this appointment if he wanted to. He had taken her out to buy chairs. He'd taken her to the doctor. He took her to Marvin's funeral a few days later. So she was perfectly capable of traveling if Bruce wanted to take her there.
I
Now,
can't believe that we wouldn't be talking about him taking her there in a different light if that's what he had done.
we would be, because there are cases that say specifically that is something that you can take into evidence when considering procurement. Here we have the opposite consideration, where is he preventing her from being seen by Mr. Collins? Because if Mr. Collins has an extended interaction with her, he's going to pick up on some of these dementia and paranoia issues, because witnesses testified you could talk to her for 3 or 4 minutes, on the phone, or even up to an hour, and everything might seem fine. And then after a while, you start to pick up on, well, you already told me that, or you told me something different. Or she would get into these stories about people are breaking into my house, poisoning my food, they're stealing things. And eventually then you'd pick up on these things that aren't true. One of the things
But doesn't that make it sound as though this will, whether it's rational or not, is a result of her choices?
No, I don't
And
believe
you're
so.
suggesting that her son put these ideas in her head, but by the same token, you're suggesting these ideas live in her head.
So you're asking if dementia, if she makes a demented will, is that will still acceptable if he is the one that put her up to it? And the answer to that under the undue influence case law would be the more demented she is, the less evidence of undue influence needs to be provided to establish that presumption.
But
And
what's
here,
the evidence that these thoughts are the result of his influence?
that we have years of evidence from siblings, from grandchildren, from other people that it would not take very much for someone to say, hey, remember that you thought that Vicky was stealing from you? And those are the things that she relayed to Mr. Collins, that, oh, these people were stealing from me, even though it wasn't true. All of the evidence that this didn't
But you're
happen.
suggesting back in 2017, when she went in and you have Dr. Chamberlain's report that there was paranoia and she was concerned people were stealing from her. Where is the suggestion in that report that that came from Bruce, that he's the one? That's what I think Justice Doherty is getting to, that he's the one that created that. Was there evidence where he was telling other people in the community that his siblings were stealing? How do we attribute that directly to him other than something she simply just, from your position, incorrectly believed?
Well, she incorrectly believed it for a long time. And there are cases that hold when the beneficiary isolates.
But was that her belief? That's the question, is it's her belief.
I guess that's a philosophical question of, is dementia your own belief or not? If you have a dementia.
But do you have evidence that it's attributable to Bruce?
And we're past the point of competence, right? We're not talking about competence.
No.
Right. We're not talking about competence. We're talking about a person who is susceptible to undue influence and is put in a situation where she doesn't have independent counsel. She's not meeting with the attorney. The attorney has no opportunity to judge. The attorney doesn't even know who's present in the room. You know, there was a suggestion that, well, he didn't hear Bruce over the phone, so therefore Bruce couldn't have planted any of these thoughts in his head. And there's no way to believe that. I mean, Bruce could have been handing her cue cards to read for all anyone knows. And looking at the totality of the circumstances of what occurred here, it is reasonable to believe that Bruce orchestrated this situation this way. As Justice Doherty just pointed out, if he had drove her to his own lawyer, we would be talking about that, right? That he orchestrated a situation to take her to a lawyer, and the case law supports that. It makes no difference in my mind why we wouldn't say, okay, we have a person with dementia, and if they go to meet a new lawyer, that lawyer might find out something is amiss here. So we're going to keep her isolated and have her only have these conversations over the phone. And when we read the notes, we can see she is still going through these paranoid fantasies. And now it's, well, Bruce is my own real only child, even though we know from the history what she's saying is just not true. That she gave someone
we know that the evidence suggests that Bruce arranged for the witnesses. Is there anything untoward or suspect about the witnesses? Is there any alignment that they have with him? Anything other than the fact that he's the one who went to the bank and got a couple people to witness?
They had a prior banking relationship, I believe, which is how they knew to go to that bank. I believe, I can't remember off the top of my head, but I believe Mr. McConkey and Mr. White had some sort of relationship, but I can't pinpoint it off the top of my head.
Just with Bruce, without, not his parents?
Well, with both of them, I believe.
Okay.
I believe there was some sort of loan relationship. I'm not alleging that they went in there and did this and cooked this up because they had some loan relationship with Bruce. But,
right. But having witnesses is a good thing to make sure that there's not undue influence.
It is a good thing. And when you read the original testimony under oath from the prove-up hearing and compare it to the affidavits from those people, you see two wildly different stories. Mr. McConkey testified that he couldn't tell one way or the other whether Eva Lou even understood what she was signing.
And was that introduced on the motion for summary judgment?
It was, yes, it was a transcript from the prove-up hearing that is in the record and was talked about at summary judgment.
And do you agree that information, when we're looking at the judge's ruling on summary judgment, we only look at the information the judge had, not at information that may have been developed later?
Correct. I agree with you. Yeah, we're here today to decide whether the judge, under the evidence that he had in front of him at that time, there was a question of material fact at that point in time. So while I do believe there is evidence in the record to establish she had dementia, the best evidence, of course, is the testimony from the doctor that did not come later. But we certainly have enough evidence from all the witnesses who testified to it, from the prior doctor's records about paranoia at the time of summary judgment. And to your point, the trial court judge did in fact recognize the misinformation in those affidavits and in the earlier trial testimony from the witnesses to the will.
So
Thank
at this point, yes, your time is up, but you will have time on rebuttal.
Thank you.
Right. Mr. Minold?
Thank you. May it please the court. Good afternoon, Your Honors. Noah Menold on behalf of the defendant appellee, Bruce White. I want to address 4 points. The first one is that as to counts 2 and 3, plaintiffs can't establish undue influence because there's no admissible evidence that Bruce prepared or procured the will or otherwise overrode Evolu's free will. Undue influence is not merely influence. To invalidate a will, the plaintiffs need to prove influence operating at the time of execution. That would be January 9, 2019. Influence directly connected to the execution of that instrument. Influence specifically directed toward procuring the will in favor of the beneficiary. And finally, influence sufficient to overcome the testator's free will. The plaintiff or the plaintiffs, must prove the manner in which the testator's free will was impaired.
Actually, counsel, isn't it more correct to state that they have to raise an issue of fact as to those issues?
Correct. To survive a Celotex style motion for summary judgment, they need admissible evidence to satisfy each element of that claim.
And would it not be appropriate to say material fact? I mean, would that adjective not apply
That is more correct.
to
Thank
summary
you.
judgment? I don't know about
That is-
more correct, but just as an additional modification.
That is
Okay.
the correct legal standard, yes. So here, the undisputed material facts are this. Evolu personally spoke with Attorney Collins. The consultation lasted 46 minutes. Evolu provided dispositive instructions. Evolu explained her wishes. Attorney Collins took detailed notes. They're on yellow legal pad. He then drafted the will accordingly. Attorney Collins testified that him and his office were the sole preparers of the will. So preparation is now taken off the table. There is no admissible evidence that Bruce prepared the will. The question under the undue influence counts is, did Bruce procure the will? Bruce, according to Attorney Collins, never talked to him about the substance of the will. He never instructed him regarding beneficiaries. He never made any requests regarding the substance. The testimony of Attorney Collins is unrebutted. Evolu requested the estate plan. Bruce did not participate in the substance. Bruce did not dictate the terms. Mr. Collins testified that he has no reason to believe that Evolu was being influenced by anyone. Plaintiffs
Well,
have no...
he wouldn't know. All he had was one telephone conversation. How would he know whether Bruce was influencing Eva prior to that telephone conversation about what her estate plan should be?
I guess to answer your question directly, the only thing that Mr. Collins would know is what transpired during his 46 minutes and change conversation.
Right.
And he
But that's
testified...
not the only time Bruce could influence Eva, right? It could happen before.
Yeah, I guess anything is possible. What we talk about...
I don't think the case law says that you have to sit there and direct the person as they're talking to the lawyer. Influence can occur before the conversation with the lawyer.
I agree that influence could happen before talking to the lawyer. The problem is, in this case, there's no admissible evidence that that happened. Suspicion is not procurement. Plaintiffs rely upon alleged opportunity, but opportunity is not undue influence. The case...
Let me stop you there for a minute in terms of when we say, did he not move into her home? Was a caregiver for her, was responsible for helping her run the farm, all these other daily living tasks that were required. Did he not serve in that role for her, both in a business sense and a personal sense?
So there's several questions there. I'll try to take them piece by piece. Marvin is Evolu's husband. That's the father of Bruce. He was receiving hospice care in late December. Bruce testified that on December 28th, I recall, of 2018, he moved into his parents' house to administer morphine. The will is executed January 9. So I guess that's the window of time we're looking at. Bruce testified that he never provided medications, toileting, dressing. Like that was not his relationship with his mother. Did Bruce provide labor for his parents' farm? Yes, that is a fact. But the nature of their relationship, the evidence is from Bruce. And if you look at the plaintiff's testimony, they testified that Bruce was this like absentee figure in his parents' life. Regardless, the evidence, I would agree with you that Bruce did directly participate in his parents' farm before Marvin's death and continued to do so after Marvin's death. But going back to the specific nature of their relationship, I guess what I'm saying is at most plaintiffs have that Bruce was present in Evolu's life. Bruce benefited under the will, sure, but where is the admissible evidence that Bruce unduly influenced Evolu? They're asking that an inference be drawn from pure speculation and conjecture, and that's not enough. I would direct the court to two cases, Mosher versus Thrush and Dowie versus Sutton. It's in our brief. Those cases talk about how advice, persuasion, argument, affection, and influence are not undue influence where the testator acts voluntarily. And we had a whole trial on the issue of testamentary capacity. The plaintiff's theories of insane delusions were tested. The jury rejected them. The jury found that on January 9, 2019, the presumption of testamentary capacity was there. The plaintiffs did not.
What's good for the goose is sauce for the gander. If we're limited to looking at the record at summary judgment, aren't we also precluded from looking at those subsequent jury findings?
I guess, Your Honor, we would be had the plaintiffs appealed that issue. They chose not to. So there's no unringing that bell. The jury has decided.
Bell hadn't rung at the time this motion was decided.
At the time this motion was decided, testamentary capacity was not an issue. The issues before the court were counts 2 through 5.
So we could neither add to nor detract from the record that the judge had at summary judgment by looking to something that happened later.
I agree. What I heard during this oral argument was a lot of argument about what doctors said at trial, what happened at trial. And if that is the standard, then yes, we need to look at the record on October 16th, 2025, when the motion for summary judgment was argued. That record is defined. It is before you. You got extra stuff. There's lots of transcripts from what happened at the trial, but the issue is not testamentary capacity. Even if we disregard what the jury decided, the issue at summary judgment was, did Bruce unduly influence his mother? And the burden for proving that is the plaintiff's. And so there are specific acts of undue influence. That's count 2. Then there's count 3, which is the presumption of undue influence.
Can I just stop you there? Isn't the burden on the moving party to demonstrate the absence of a material issue of fact?
Correct. I apologize if I misspoke there. What I'm saying is it's a Celotex style motion. The assertion on behalf of Bruce was that the plaintiffs lack sufficient evidence to establish each and every one of those elements. So I guess the opposite end is that the plaintiffs have the burden to come forth with evidence to establish each and every one of those claims. And what I'm saying respectfully,
to create an issue of fact as to each one of those claims.
Agreed. And respectfully, what I'm suggesting is that they failed to do so. In specific, and count 2 are the specific acts that Bruce allegedly took. And Bruce's actions are what I would liken to logistical. They're not substantive. There are unrebutted Rule 191 affidavits of Mr. McConkey and Ms. Munson. They weren't deposed by the plaintiffs. Those affidavits state Evolu called the bank and requested that they witness her will. Then Bruce came by to schedule the will signing. That is not affecting the substance of the will. At best, it's procuring the execution of the will. But as In re Estate of Henke, which we cite in our brief, says, the mere fact that a beneficiary provides transportation to a law office for a testator raises no presumption whatsoever of undue influence. It's just like that. Had Bruce driven his mother to the bank to witness the will, that would not have been an undue influence. And I respectfully submit that Bruce reaching out to those witnesses to arrange for the exact time for which they would accept her invitation to come witness the will is not evidence of undue influence. Plaintiff's counsel suggests that there's this giant contradiction in the prove-up testimony versus what these affidavits say. I would request your honors to look at that testimony. That testimony didn't touch on the subjects of the affidavits with specificity. We're trying to read into these two things as some contradiction, but the fact remains they're unrebutted. There's 4 people on this planet that could have testified as to who was present at the will signing. Eva Lou, she's not here with us anymore. There's Bruce White. He testified that when the witnesses arrived, he left. And then the witnesses' affidavits say, we remember seeing Bruce. We don't remember him being at the will signing. That's the evidence. And so with respect to count 2 and specific acts of undue influence, I respectfully submit there's a lot of speculation and conjecture, but that's not enough to survive summary judgment. There has to be a question of fact as to those elements. With count 3, the presumption of undue influence, it's a little bit different because there's the next element, which is different from count 2, which is the existence of a fiduciary relationship. And initially, that argument was that Bruce owed a fiduciary relationship because of a power of attorney for healthcare. But there's case law on point that says that that is not the type of relationship to create a fiduciary duty. In this specific circumstance, that would be in re a state of stalling. So then if there's not...
So what about, excuse me, so what about the power of attorney for property, which was signed at the time the will was signed? Does that create a presumption? And if not, why not?
Well, let's take that 2 steps. 1, does the execution of a power of attorney for property create a fiduciary duty? Absolutely. However, it's
Legally.
the sequence. Yeah, the sequence is that the will and the power of attorney were signed or executed at the same time. So there was no fiduciary duty as a matter of law for Bruce prior to January 9, 2019, which happens to be the same time that Eva Lou executed her will. So if there's no fiduciary duty as a matter of law, the question becomes, was there a fiduciary relationship as a matter of fact? And the case law, I'm going to call it the Baumgard case, it's in my brief, says that that must be proven by clear and convincing evidence. But there's other case law, in re estate decline, that cautions a parent-child relationship. It's often marked by the characteristics of a fiduciary relationship, being that there's trust and confidence imposed and things of that nature. And so we cite that whole string of case law where it says that caution should be used when finding such a relationship derived from fact, because again, affection, confidence, assistance, those are incidental to the parent-child relationship. So the plaintiffs had the burden of coming forth with admissible evidence to create a question of fact as to whether there was dominance or control by Bruce between that period of December 28, when Bruce moved in to help with his father's hospice care, and January 9, when Eva Lou ultimately signed her will. And what they have is their own testimony. Both Victoria Harper and Christina Werland testified that they were present after their father's death and throughout the funeral. Christina testified that she helped her mother get dressed, and both of them testified that they cooked and cleaned and things of that nature. There's no evidence of isolation or that Bruce was exerting sole dominance over his mother at that time. Plaintiffs can't produce, this goes back to procurement.
Wait just a minute, please. We've lost Justice Leonard's picture. So let's see if we can get it back.
Can you hear me?
Ken,
We can.
I can.
Okay.
There we go. Okay, we're back. I don't know what, we had some camera problems earlier today. My apologies to counsel and my esteemed colleagues. and we'll hope that it continues not to be an issue. Thank you.
Okay, go ahead. Do you
No
remember
problem.
where you were?
Yes, no problem at all. So the counts 2 and 3 are still tied by the element of procurement. So even if a fiduciary relationship existed, which we're disputing, plaintiffs still had to have evidence that Bruce somehow procured the will. And again, the undisputed material facts are Bruce didn't draft the will, he didn't prepare the will, he didn't instruct the attorney on how the will was to be drafted, he didn't dictate its terms, he didn't determine the beneficiaries. And without procurement, the presumption still fails. The last two elements are dissimilar to counts 2 and 3. Excuse me, last two claims. Counts 4 and 5 are the more financial transactions. Counts 2 and 3 are focused on the will. Counts 4 and 5 are after the fiduciary duty is established as a matter of law. January 9, 2019, Bruce becomes a fiduciary. Then there are questions regarding, transactions that transpired later. Throughout the litigation, there were really 4 categories of disputed transactions. The first being these household home furnishings of about $5,000. The evidence is, Bruce used his mother's money to replace a couch with mouse holes in it, and that he replaced a broken stove. And the mobility issues that were discussed earlier, his mother was incontinent, so that her, the marital bed was replaced. So that was one issue. The second issue was this grain bin. Bruce used his mother's money to purchase and have a grain bin constructed on his mother's property, a permanent improvement that was filled with his mother's grain. That's really the second category. The third category is farm equipment. Bruce has farm equipment repaired, traded in, some used equipment was purchased, and that's a whole group of transactions that are questioned. The evidence that is in the record is that relationship between Bruce's parents and him dated back till 1981. Bruce has his own standalone farm. It's in the same county. Parents have their own standalone farm. Bruce owns some tractors and the planter. Parents own the combine, and they teamed up their equipment in a sort of a joint venture. Bruce's father and Bruce compiled their labor and they farmed together. That's just how they operated. However, after Marvin passed away in farm year 2018, Marvin wasn't there. So Bruce continued what had always been done, which Bruce's equipment was used on his mother's farm, and Bruce's mother's equipment was used on Bruce's farm, with the caveat of the change being Bruce just provided 100% of the labor for both farms at no charge. That was the third category of disputed transactions. And then the fourth one was these 2 checks. Hey, there's 2 checks, one $12,000, one $18,000. They're made payable from Evolute to Bruce. During the course of discovery, Bruce came forth with corresponding checks showing that those checks were reimbursement for checks that Bruce had personally written out of his own account for the purchase of equipment that remains a part of his mother's estate that was used for the benefit of his mother's farm. And again, it's continued to be used as part of his mother's farm. On appeal, those 4 categories kind of morphed. The home furnishings kind of disappeared. The grain bin kind of disappeared. It's now, hey, there's other transactions that were never explained. They add up to about $10,000 over, several years. But
Or were they ever alleged? You're talking about on appeal, but were those, quote, other transactions ever alleged in the first place?
no, in the complaint, it's only home furnishings, a grain bin, farm equipment, and these 2 checks that I mentioned. On appeal, it's now 10 checks. Hey, there's checks made payable to cash. There's checks made payable to Bruce. And again, the aggregate amount is about $10,000. My point is, in bringing this up, Bruce never had a reason to defend those transactions because they were never questioned in the state court, or in the trial court, excuse me. And so without having the reason to be questioned, Bruce never had the reason to defend them. So respectfully, those arguments should be forfeited or have been waived because those were not in the record or considered by Judge Lane on October 16th, 2025.
Would it have mattered? Do we know who signed the checks? Didn't Evolue sign the checks? at least on most of these categories we're talking about?
Yes, I think the critique is that Bruce hand wrote the checks and then Evelyn would sign them. There's testimony about how they work together on those types of things. Bruce did sign checks as power of attorney, but a lot of these checks that are the transactions, additional ones, were signed by Evelyn. But again, those issues I don't think are germane for what we're doing here because that wasn't considered by Judge Lane. And again, I see my time's winding down. I'm happy to answer any questions the court may have. Otherwise, thank you for your time. We rest on our brief.
Thank you. Any further questions, Justice Doherty or Justice Landert? I don't see any. Thank you. Mr. Sokin?
Oh, you're muted, counsel.
Sorry, I didn't want the phone going off or anything, even though it's.
That's okay. We appreciate that. Thank you.
The checks weren't considered by Judge Lane, but they should have been because they were in the record and they are alleged in the complaint. The record contains hundreds of pages at the time of summary judgment of all of these checks that were written out to cash or for reimbursement or were written directly to Bruce. So those were in the record.
Counsel, can I just ask a question about your client standing to complain about that? Don't your clients have to prevail on the will contest issues to have standing to complain about the POA issues? Because if it all goes back to an estate of which they are not beneficiaries, it's neither here nor there for them.
I don't think so. I think under the POA statute, as long as you are an interested person, which the courts have held to be a very broad category, I don't believe I briefed that issue because the question didn't come up, but I believe there's a case where even someone who was considered a non-heir, I believe it was a minor child who'd been excluded, was still considered an interested person.
Who gets the benefit if you prevail? It's the estate.
Well, if we prevail and there's a breach of fiduciary duty because of a POA violation, it would go back. It would be someone different because Bruce would be potentially disinherited. So you're right. It goes back to the estate, but it doesn't.
I'm saying if you do not prevail on setting aside the will, anything that you disengorge from Bruce goes back to the estate, and he would be a beneficiary. So it's sort of a closed circle.
It is in the well, yes and no, because depending on how those claims go down, the probate court has the authority to disinherit him. So there are ways under the Probate Act for a court to say, okay, you're the one who did this, and I'm not going to allow you to profit from it. So there would still be a method in which, if it was proven that way, that Bruce did something wrong, that he's not allowed to profit from it. As far as the checks are concerned, that was discussed. It was discussed at Bruce's deposition where he was questioned about these checks when he admitted that he did not keep receipts for anything that he couldn't use except for tax purposes. That's why there's no record that was required to be kept under the Probate Act, under the Power of Attorney Act, of what he was doing. So when he writes these checks to cash, he had no explanation in his deposition for what it was for because he admitted that he kept no records. So that is in the record, and it should have been considered. It has not been forfeited or waived. It's specifically in the complaint.
Doesn't it matter who signed the check? Because he doesn't have to keep record of transactions that she made.
It matters because we know from the medical testimony that she is incapable of managing her own finances. So the fact that he just fills out the checks himself and then has her sign it is no defense. I mean, if he wrote out a check to himself and said, I'm giving myself $100,000, and just put it in front of her and had her sign it, that's no more a defense than if he did it himself. If she's suffering from severe dementia and doesn't know what's going on, because under the Power of Attorney Act, any selfish benefit at all is presumed fraudulent. Any use of the principal's property is presumed fraudulent. So this argument that, well, we had this longstanding relationship that I got to use her property. Once he signs that power of attorney, the game has changed. He is now her legal agent. He's her legal fiduciary. He has to abide by the laws of this state. He can't just take some benefit from her and say, well, we used to do it that way. It doesn't work that way anymore once he becomes agent. She could
Wouldn't
have
that be evidence, though? Counsel, can't that presumption be rebutted?
It can be, but we never even got that far because the judge said there was no evidence. It should have had to be rebutted, but rebutting it requires clear and convincing evidence that was never established at the trial court because the court never even considered it. So what should have happened is, you're right, it should have been Bruce's burden to disprove these things by clear and convincing evidence, but the court never got that far. Counsel raised that these affidavits are unrebutted. The affidavits are rebutted by the trial testimony of those same witnesses. The trial transcripts can be used just as much as deposition transcripts. So when the court reviews the record and compares those witness affidavits.
Wait a minute, what, you mean the record after summary judgment?
No, I mean at the time of summary judgment. At the time of summary judgment, Bruce produced affidavits from Clay McConkey and Rhonda Munson claiming that Bruce wasn't present at the time the will was signed. But 2 years earlier, when they testified.
Okay,
at-
not trial, but.
No,
the-
no.
the
At the
will
time,
approval. Okay.
correct, at the
The
time
will
of the
approval.
approval. I wasn't trial counsel, so as far as I
Okay.
exist, it only occurred to them. So that evidence is actually in the record. There's case law under the factual fiduciary claim that counsel said, well, he's not a factual fiduciary because they're a parent and child. The case law says you have to heavily scrutinize parent and child, but this is not your standard parent and child situation. He's living in the home. He's her caregiver. He's taking care of her financial situation. It's not your standard parent-child relationship that you would have under those cases. There's a case law that specifically talks about these situations when the child is living in the home as a caregiver, and that being a factual fiduciary.
Thank you
Thank
very much, counsel. Thank you both for your arguments this afternoon. The court will take the matter under advisement and render a decision in due course. We stand adjourned for the day. Thank you.